Okay, good morning, everyone. Welcome to Marlborough Law's podcast for this year. And to my left, we are welcomed with Sophie, training solicitor that came last time. And we welcome Emily to the firm as a legal assistant.
Hello.
Recently joined us, so we're privileged to have Emily on board. And this week, they've put us to the test and they decided to ask me questions on TOLATA. Now, I don't know what the questions are, so it's going to be see how we get on. If I don't know the answer, if you can cut it out, that would be much appreciated. And then we can roll back on another time. But yeah, go ahead. Whatever you've got to ask me, go ahead.
Okay, hitting you with the hard-hitting questions first. I just wanted to establish, what is TOLATA?
So TOLATA in its form is the Trust of Land and the Appointment of Trustees Act, which came in 1996. Effectively, what it does is a trust of land who is responsible, who is the beneficial interest of land, effectively.
Okay. So what is a beneficial interest?
So the beneficial interest could be two people owning the property in equal or unequal shares. But it can also be, and this is an interesting point, and I'm glad you raised the question, was someone could own a property, but someone else that's not on the title could own a beneficial interest in that property, which flows from the relationship all the time that they spent in that in the property. And
was there any particular reason why it was introduced, or?
Yeah, it was to protect cohabitating partners, albeit that in those years it was more people married, but nowadays more people cohabit.
Yeah.
So surprisingly enough, actually 30 years next year, we'll see the 30th anniversary of TOLATA, and we're seeing it being played in the courtrooms more often now than what we were at the Marriageable Clauses Act.
Yeah.
Strangely enough. So it's a good podcast to do, I suppose.
Yeah. And in which situations might a claim arise?
Oh, wow. That's a broad question there.
Yeah.
So claims can arise in different circumstances depending in cohabitating proceedings.
Okay.
So if one person, let's take different examples just to mirrorise it. So if one person's ousted from the property, they may make a claim for the force of the sale of the property. Okay. Because if they've got a mortgage with the other partner and they're paying that mortgage, they might feel grieved that they're paying into a house that they're not getting the benefits from.
Yeah.
So not getting a beneficial interest of that property. So if they're ousted from the property, it might bring rise to a Section 13 claim under TOLATA, which is for occupational rent.
Right.
Now, that could work out a different scenario, as you'll find out. But generally, people make a Section 14 claim under the TOLATA Act, which is a force of sale. But it would be worth minding that case law suggests that the force of the sale should be the secondary, and the offer to purchase the property from the other party should have the offer first. So it may be wise to not jump in and do a TOLATA claim because there's certain procedures beforehand, because costs are very live.
Oh, really?
Very, very live in those cases. As soon as a pre-action letter starts and costs start rolling with it.
Yeah.
So knowing what you're doing is really important, because otherwise it can fall foul of costs against you and normally awarded.
Kind of leads into my next question, actually. Do you actually need a solicitor to do a TOLATA claim? I mean, obviously, with working with solicitors, we'd probably say yes, but...
Yeah, so naturally you would.
Do yourself out of a job.
Yeah, pretty much.
Absolutely. So the issue you get is the pre-conduct of parties is extremely important, actually more important, I would say, at an early stage to the claim, because, like I say, costs will start at the pre-action letter. A pre-action letter needs to be fulfilled in what the parties are seeking, but in negotiations on the table. So before you make what we call a Part 7 or a Part 8 claim, I'll explain that a little bit in a minute.
Yes.
And that's why I would suggest always appointing a solicitor.
Yeah.
The pre-action letter negotiations would need to. And it would normally follow the pre-action letter would be your accounts. So we'd look at the accounts of what the intentions of the parties were, any minors that have come into play, any declaration of trust.
Is that Section 15?
Section 15, that's the one. Yeah. There's 4 different requirements that the courts would need to established first.
Okay.
So you want to get your ducks in order
Mm.
before you start making these applications.
Yes.
Prior to it. Now, I don't know whether you've got a question on part 8 or part 7, so I might leave that for the time being.
No,
No?
I don't.
But the reason why we have a part 7 or part 8 claim, part 8 claims would predominantly be where you have a declaration of trust or you have something in place where you're looking at the mechanics of how you sell the property or where someone buys you out, etc., etc., because you've already determined the share in the declaration of trust itself, or you would normally. Now, a poorly written declaration of trust can arise to other issues.
Yeah.
And also not reviewing your declaration of trust can also arise to other issues. So a part 8 claim would be traditionally the easy option. It's front loaded. So normally you would provide a witness statement along with your application. Just as long as you follow the pre-steps, they're the most important thing. Costs are not as alive as maybe as what it could be, and so there could be a reduction. So not doing mediation and things like that could bring rises to claims for costs.
Yeah.
Part 7 claim is more of a complex claim. In other words, it can be heard in the civil courts, or even you can make an application to the High Courts. But then, that's when you're making applications for occupational rent under Section 13, or you've got the minors in the property that the couples have decided to have children.
Yeah.
And you've got obviously the court's primary concern is the children until they reach the age of 18. So your declaration of trusts in a Part 7 claim could actually fall if you've had children and not reviewed the declaration of trust. So in answer to your question, I would point a solicitor that knows what they're talking about, because the cost of it doing yourself could be very costly in the end, and you could lose the equity in your property by not appointing the right person.
Okay.
And I think kind of following that, what sort of things do the courts need to take into consideration when making a decision in a TOLATA claim?
So our overarching decision would be if the party's intentions at the time of purchase, and that is a time of purchase, what their intentions were, who should have what share. And that would normally be shown upon your transfer form when you purchase the property together. Also, which comes live, which we're just saying, the declaration of trust would come live into play, and the courts would take that into consideration. These are express trusts, but also then the courts may take into consideration implied. So if some person's put in more money throughout the relationship, and it was loaned, they might take into consideration the construction of an extension. Children is obviously the overarching for any court. In any circumstances, they would be their first and foremost consideration. So it seems quite simple to just force the sale of a property because you have 50% share, but actually other things can come into play. That's why it's worth getting your ducks in order before make the application.
Yeah, it's a lot more complex than it seems.
Yeah, and it can be quite, and some people will use a Part 7 claim to sort of push as we say, dragging the heels. So if someone's got a beneficial interest in the property, there's no real reason for them to leave because half the mortgage is being paid. So they might make a Part 7 claim just to push the heels of those that are dragging, that have got the benefit of the property at that time. So it's really important that there's technical moves that you can make just to speed things along or to make things fairer, actually. And, why should you be deprived of a property and paying a mortgage for a year, 2 years, and paying rent on another property? And then you've got children involved, which could be children to the partners, to the parties, which then can cause problems thereafter. So, like I say, a good drawn-up declaration of trust, which is reviewed, is always the best. So the court's consideration will always be around those areas, certainly. And you can find that if you're making those applications.
Okay. This question might not have a straight answer at all, but how does TOLATA address situations where there are disputes regarding its use or its sale and the parties can't agree?
How would it benefit?
How would they address, how would they go about resolving that if they can't agree on what one party wants to keep it, one party wants to sell it?
Okay, so, well, it's a good question, actually, because if you haven't got the trust declaration in place, and how did the courts determine what share or what isn't when they initially purchase it. So what we would do is when you do the accounts for the clients, so we'd look at all the information similar to that of the families, but bank statements and things like that.
Oh,
So
okay.
if one party's paid the mortgage and the other party's paid all the bills, there may be intentions that it was an equal share. There may be money that's being provided on a loan. Now, some would argue that it could be what we call a hard loan, where there is an agreement in place with one of the parties' family, and equally what we class as a soft loan. Now, the courts may take that into consideration, certainly if there was a soft loan in place, but on the rare occasions that would happen.
Yeah.
And then the court's job really is, and it is really a difficult job for them to do, is determine what the share actually is. The transfer form actually is a huge benefit to the parties. So because that normally expresses exactly what the intentions were at the time of purchase.
Okay, that's interesting. So they don't just side with one, or they just take into consideration everything.
Yeah, the strange thing about that claim and also claims under the Marriageable Act is that it's so broad.
Yeah.
And each individual's circumstances are completely different. And can weigh bear on a good 10-15% of the property being allocated to the other party. So it's always worth seeking advice.
Okay. Does having young children living in the house impact their decision at all?
Yes, absolutely.
Yeah.
The overarching decision of any courts is always the children, because the children have come or been born into a situation which they haven't chosen to.
Yeah.
Now, naturally, the later you get on in life, if your child's 16, 17 or 18, they may well defer the force of a sale of the property, certainly if one party can't buy out the other party till the child reaches 18, which would normally be the circumstances. But then on top of that, if you've got a child that's 18, in fact, you could then look at medical conditions of that child.
Yeah.
You know, whilst a child is 18 and considered to be an adult, there may be medical conditions that won't allow for the sale of their property because of the influx of the medical condition of the child. So there's many areas that the courts, but overarchingly, the children
So it's
will
a very
come first.
broad.
It is, yeah. Obviously, the younger the children, the likelihood is it may be that they can't force the property sale at that time, and it might be deferred to a later date.
Okay, interesting. And what are the outcomes? There's no probably straight answer to this one either, but what are the outcomes of TOLATA claims? They can obviously order a sale.
Yeah. No, absolutely. So when you put your claim in, it be a Part 7 or Part 8 claim, Part 7 you'd put your particulars of claims, whereas Part 8, like I was saying, is front loaded, so that would normally be a witness statement. So Part 7 claim, you'd be your particulars of claim. So the outcome of your claim would generally be formed on those particulars. The other side will have a chance to respond to those particulars, by the way. And generally speaking, it depends on the circumstances that whether they force to sell, whether occupational rent is provided. So if one party is ousted from the property, and certainly case law suggests that you don't need to be ousted from a property anymore, just the fact that you've lost your beneficial interest.
Oh, really?
And then the percentage of the occupational rent is normally worked off. It's currently worked off of minus your mortgage interest rate and then half the rent. So what you would expect to get for that property at that time of the mortgage interest rate. So there's one side. But generally speaking, in my experience, the 12-month window is when a forced sale would come into play, certainly if you've got children.
Yeah.
Because it leaves a 12-month window to impose such a strict window would be unfair, I think, and disturbing on the children. So, that's why I would sit with it.
So would you recommend putting a declaration of trust in place as soon as you get a house with somebody? Is that something you do before? Where would that come into play with this? Or is this something that the court orders?
So, no. So the courts wouldn't normally interfere with a person's private life. So a declaration of trust should be or ought to be suggested by your conveyancing solicitor if you're cohabiting parents. And a good solicitor would always, I would say, recommend doing one, certainly if you're cohabiting. And every time of conveyancing. Now, you can register the declaration with the land registry at the time of registration of the land or the property, and that's always a good thing. and it can always be updated. So if children come into play, if gifts are given,
Yeah.
loans are given, houses will have new kitchens and one party would provide the money.
Yeah.
You can always review it and upload a new one, but I would always suggest and welcome parties to submit their declaration at the time of purchase and
Okay.
certainly review it if they move.
Yeah, absolutely. Well, that's all my questions.
Is that all your questions?
That
You
is all
got
my
any more? You
questions.
got nothing more for me?
And just how easy is it to set up a declaration of trust?
Well, strangely enough, declarations are not that hugely difficult. It's more the detail that needs to be. So every avenue or every question's got to be asked. And from a lay person, you might just sort of see life as very much straightforward. We've got a child, may not have a child, or this is what our future looks like. Which, generally speaking, in society, most people's views or ways of society will always flow from that. But it's always worth getting that advice, legal advice, so you can actually pin down on the necessities. So the trigger points is one of the things, like when would the trigger point come into play under declaration. One declaration I did was they had a young child together and the child was 8 at the time, and if they were to separate, they would have a 2-year window for either party. So the house would go up in the sale, or one party would buy the other party out, but they would have a 2-year window to which to do so. Where the court's normal way of dealing with that would be when the child reaches 18, maybe, because it's the idea of providing a home was for a family home, so that would fall under one of the requirements. So if the house was for the benefit of the family, then they shouldn't be deprived of that. But you can put in any little detail that might help the couples. And the idea of it is to stop the arguments and the cost flowing from the separation. The separation's bad enough and emotional enough between the two parties. And the idea is to remove that argument before or if it should occur. But we don't want that to happen naturally. But it's always worth protecting your interests. Well, thank you very much indeed, both. You really put me on the spot there. Glad well, if they were wrong, I'll have to review it. But yeah, no, thank you very much indeed.